Good morning, or depending on your time zone, good afternoon, everyone. Thank you for joining us today at the Product Liability Law Recent Updates Relevant to Manufacturers and Sellers of Products webinar that we at Fasken are happy to put on for you today. And just while I'm making my opening comments, please see the information slide that you will now see on your screen. I'd like to draw your attention to the Q&A piece. We encourage you to submit your questions throughout the duration of the presentation, and we'll be saving time towards the end of the webinar to address as many of the questions as we can. But certainly if you think of questions afterward, or if you have questions that we're not able due to lack of time to address today, we also do invite you to feel free to reach out to any of the speakers by email if you'd like to speak with us offline subsequently. And also, one other matter of housekeeping, we have an automatic CPD certification process for our webinar. At the end of the webinar, there'll be two options for you to automatically receive your Ontario or Quebec CPD certificate. A QR code will appear on the screen, and you can use that link, or you can use that, or you can use the link that is added to the audience chat at the end of the webinar. Now, just briefly by way of introduction of the speakers before we jump into the webinar content, my name is Peter Pliszka. I'm a senior partner in the Toronto office of Fasken. I am the chair of Fasken's National Product Liability Group and also chair of our Life Sciences Litigation Group. My practice is primarily focused on product liability and class action litigation, and it's national in scope, where I handle cases in all of the provinces across Canada. It's my pleasure to now introduce to you two of my friends and partners from offices to the east and to the west of me. First, to the west, Michael Parrish is a senior partner in the Vancouver office of Fasken. Michael is a specialist in product liability, tort, insurance, class action, construction, and aviation litigation. Michael is recognized in BC as one of the leading specialists in product liability law. And then to the east of us here in Toronto is my friend and colleague, Noah Boudreau. Noah is a partner in our Montreal office. His practice also is primarily focused on product liability, class action, consumer protection, and cybersecurity law. And Noah is actively involved in handling the Quebec end of all the product liability class actions that come up for our various clients here at Fasken. And I can tell you he has for many years been my go-to person in the Montreal office for all things product liability and class action related. And so on that note, I will now pass the baton to Noah. Noah will commence our presentation by telling you about some developments in this area of law in the province of Quebec, and we will then move from east to west through the remainder of the webinar. So Noah, take it away.
Thank you, Peter. Thanks for the introduction, and good afternoon and good morning to everyone. Thanks for joining. I am going to cover three main topics. I'm going to try and cover three main topics. I have an ambitious agenda, so we'll see if we can get through all of it. I'll start with my shameless promotion, which is if we don't get through it all three topics are covered in bulletins, which we've written and which can be found on the Fasken website, and which I think might be made available somehow through this presentation or afterwards by way of note. The first topic I'm going to address is product recalls in Quebec and possible class actions, some tips for manufacturers that come out of particularly one of those cases. Secondly, the rise in novel product liability claims in Quebec. This is a hot topic, very recent hot topic. And thirdly, Bill 29, which is another hot topic in Quebec, which is a new act to protect consumers, which amends our Consumer Protection Act to provide for warranties of good working order and right to repair provisions against planned obsolescence and what we would call a new lemon law against defective vehicles. And I'll get into some of the details of that. So without further ado, thank you. The first topic, do product recalls justify the commencement and authorization of a class action in Quebec? So where a voluntary or government-ordered product recall occurs, particularly with respect to motor vehicles or consumer products targeted to infants, plaintiffs' counsel in Quebec are usually quite quick, and I would say very quick, to run to the courthouse to file a motion for authorization to institute a class action. As many of you may know, the bar for authorization in Quebec is a low one, even lower than in all of the rest of the common law provinces. And so where there is a product recall, it's very common, again, particularly in those two areas, to see a class action filed. And so where there is a product recall, plaintiffs' counsel, petitioners often argue that a voluntary or government-ordered recall constitutes an admission of liability on the part of the seller, manufacturer, distributor, or at the very least, demonstration of an arguable case of liability on the merits, which is the test, the really low bar that they have to meet in Quebec. And the courts have concluded that the question as to whether a product recall constitutes an admission of liability is a common question that can be determined by way of a class action. And so with the low bar, one might think with a product recall that a class action would be automatically authorized. And while it might be easy, it is not automatic. And courts have decided, at least in a sliver of jurisprudence, which I'll get to in a second, to analyze the recall and the damages that might be suffered by the potential class. Next slide, please. So the decision I'm referring to is the decision in Pocket versus Samsung. As mentioned, we have a detailed bulletin on this on our website. If you're curious of knowing a bit more information about the case, it's a 2020 case from our Superior Court, where the authorization of a class action further to the recall of the Samsung Note 7 cell phone was instituted. That was for the overheating of the batteries in the Note 7 Samsung cell phones. Class action was instituted following that recall, and the class action was refused, one of the few to be refused in Quebec. It's quite a feat these days to refuse, to have an authorization refused in Quebec. This case was refused further to a product recall. The authorization was refused since Samsung, upon discovering the defect, so the overheating, acted really quickly and fulfilled its obligations by recalling the sold products and then offering buyers fair compensation for those products. And the court confirms in that case that a product recall does not always justify a class action. And I've put a quote here on the screen, which is interesting. And this is a translation. This is my translation. So the original judgment is in French. But in refusing the class action, the court said, and what I think is interesting here, otherwise, every case involving a product recall would justify the authorization of a class action, regardless of the context and the remedy offered. In actuality, access to justice has limits. Not every problem or annoyance is worthy of being decided by the courts. While class actions help preserve judicial resources, they should not be allowed to invade the system without a minimum of filtering. And so, next slide, please. And so in that case, and despite the Supreme Court's teachings, which have said that the mere possibility of damages being suffered in a case is probably sufficient for authorization, the court here notes that nothing prevents the court from looking at the damages and assessing whether there has been adequate compensation offered that might offset any of the damages that are being alleged. Here, in this case, the petitioner's alleged damages, most of which were for trouble and inconvenience following the recall, were found to be purely hypothetical and theoretical. And the court noting that she received a full refund for her device, along with an additional credit of $100. And so, with respect to the troubles and inconveniences, the court noted that those were normal annoyances presented by everyday life, product recalls being a part of everyday life, obviously, and that the damage did not rise to the level of compensable loss in Quebec. Next slide, please. And so the decision confirms that manufacturers can, in fact, minimize the risk of litigation or a class action in Quebec by doing two things: expeditiously recalling their products as soon as possible, and number two, offering buyers reasonable compensation. Now, obviously, whether the timing of the recall and the compensation offered is sufficient will be a case-by-case analysis. And indeed, in multiple cases, which I'm not showing on the screen, the Superior Court, further to a product recall of a motor vehicle, for instance, has authorized cases where there was even minimal compensable damage alleged. So any out-of-pocket expenses further to the recall, for instance, have been deemed sufficient. So there is a glimmer of hope, and I think Samsung provides some interesting lessons for manufacturers in the class action context. Moving right along, the next slide, and this is quite new, as I say, rise in novel plaintiffs' theories and product liability claims in Quebec. Next slide, please. Thank you. So there's an increasing trend in advancing product liability claims in the absence of what we would call traditional latent defect or design defects or failure to warrant allegations in Quebec, which traditionally made up almost all of the individual and class action claims in Quebec. Plaintiffs now are seeking to extend the favorable no-fault regime, which applies in Quebec to product defects, to new property, such as video games and social media platforms. Plaintiffs are, in fact, drawing on the recent successes, and I say recent because we've just received an authorization judgment in the opioids class action case, but on the cigarette and opioid class action case, plaintiffs are drawing on sort of the playbook in those cases and applying the safety defect allegations in those cases to new property, mostly video games and social media platforms. In fact, as I mentioned, the opioids class action was just recently authorized on April 10th, 2024, so last week. And obviously the delay to appeal has not expired, but that's a very recent judgment that, as we will see, has clearly impressed some plaintiffs' counsel who are already using the same language in new cases filed, and I'll get to that in just a second. So what's a safety defect under the civil code? That's fine. We can stay on that slide. In a decision called Boudreau versus Abbott Laboratories, I think the court provides a good sort of summary of that. They describe it as goods that do not contain latent defects, yet by reason of their inherent danger, the manufacturer is required to give the user a warning as to the existence of such danger. And that's how the court describes the safety defect regime under Articles 1468 and 1469 of the Civil Code of Quebec. So here we are. Just make sure we're on the right slide. Yeah. So FN versus Epic Games, a 2022 motion to authorize a class action. First class action filed in Canada and one of the first in the world to be authorized against a video game developer on the basis that individuals developed a video game addiction, which they term video game use disorder. Very interesting because in the opioids litigation, which Peter and I are involved in, opioid use disorder is at the center of the claims in that case. In this case, they just substitute that for video game use disorder, which admittedly has a lot less scientific literature and studies on, but has been recognized as of 2018, I believe, by the World Health Organization as a disorder, and recently by the American Psychiatric Association as well. So this is a class action brought on behalf of all individuals in Quebec who developed an addiction after having played the video game Fortnite Battle Royale, and which they allege had harmful effects on the personal, family, social, educational, professional, or other important areas of their lives. The Superior Court concluded in that case that even if American psychiatrists required more research, or Canadian psychiatrists, or a video game disorder is not yet a recognized diagnosis in Quebec, because it is not. The plaintiff's claims were not frivolous or clearly without merit. As for the lack of expertise, because there was no expertise filed in support of the motion, the court concluded that it's not a determining factor in Quebec, since expert evidence is not required at the authorization stage. And this was just intending to be a screening process. And so the court authorized this class action. I should note that leave to the Court of Appeal was sought by the defendants in that case. That was refused in February of last year. And so the case is now proceeding on the merits, but it is an authorized case. And so we're at the next slide. Yes, thank you. Interesting to note that in this case, the court considered the Fortnite video game to be property, at least for the purposes of authorization within the meaning of the Civil Code. This is important, obviously, because the defendants could be held liable for damages affecting that property under Articles 1468 and 1469. So, like an opioid, which is much easier because it's actually a physical medication. They extended that, at least for the purposes of authorization, to say that the video game at least seems to be property for the purposes of authorization. This qualification raises a very interesting and novel question, which obviously hasn't been decided on the merits yet, particularly in the case of online video games like Fortnite. These games are often referred to by developers as games of service, since they require continuous support. And they can be financed in a number of ways, including by in-game advertisement and subscriptions. And so one certainly might argue that a video game, and particularly an online video game like Fortnite, is not property within the meaning of the Civil Code, but rather a service, making the product liability regime inapplicable. Of course, defendants in that case were not able to make those arguments at authorization, but those are the interesting questions, I think, that will that arise from this first case and other cases that have followed, and I'll get to that in a second. Next slide, please. So this first authorization in Quebec did not go unnoticed by plaintiffs' counsel at all. Proposed class actions against social media platforms, so not video games, but similar social media platforms, were filed quickly after that authorization, and once leave to the Court of Appeal was refused. Decision Robert versus Meta Platforms, Inc., 2023 case. It hasn't been decided. It's actually suspended currently in Quebec, but it is a proposed class action for damages on behalf of all people who are under the age of minority when they acquired and used either Facebook or an Instagram account. And the allegations look really similar to the ones that were made in the Fortnite class action. Alleged that the defendants collect data generated by user engagement, and that this data is then used to increase user engagement in order to extend the time that users spend on a product. And that the defendants would have specifically designed algorithms to identify content that was most likely to engage a user, to provoke a response, etc. The plaintiffs are obviously looking for damages in this case. As I mentioned, it's suspended for the moment. But we can see that this novel theory of a safety defect affecting software or a video game or a social media platform is being actively explored by plaintiffs' counsel in Quebec. Next slide, please. So hot off the press, Simard versus Electronic Arts and al. This is a case that was filed only a few days ago against 33 defendants, video game publishers and or distributors. And again, the allegations look almost the same. So video game addiction, internet gaming disorder after using video games. And This has, as I mentioned, just been filed, a motion for authorization to institute a class action against 33 defendants. Plaintiffs' counsel, who's not the same as plaintiffs' counsel in the Fortnite class action, has carved out the users of Fortnite from this class action, so it includes everyone else for almost every other video game that could be played and allegedly become addicted to in the province of Quebec. So stay tuned. This is a novel theory, but certainly an active one right now in Quebec. Mindful of my time, I'm going to continue on to my third and final topic, which is Bill 29, and I could probably give a few day presentation on this, and I have actually, and will continue to do so. So if this is of interest to you, happy to take those questions offline. We have a lot of materials on our website on this as well. Bill 29, an act to protect consumers from planned obsolescence and to promote the durability, repairability, and maintenance of goods. On October 3rd, 2023, the Quebec National Assembly passed Bill 29. It was assented to this past October 5th. It's a big act and an important one for all manufacturers and distributors in Quebec. The Quebec Consumer Protection Act, which most people already know is very consumer and buyer friendly in Quebec, certainly the friendliest in North America and possibly the world, has been further strengthened, believe it or not, to provide even more obligations on merchants and manufacturers in relation to the quality and durability of their products. It creates further obligations concerning the availability of spare parts, repair services, and information needed to repair those services. I'm going to just try and touch on a few with the little time I have, and I'm looking down at the time. So if I am running out of that time, someone will let me know. But I'll try and whip through to the next slide. So I talked about it creates a new warranty of good working order for certain goods for specific durations. And I'll speak about that quickly on the next slide. Guaranteed availability of spare parts and certain obligations on automobile manufacturers, including the ability to declare at the consumer's request an automobile to be a seriously defective automobile. This is what we're calling the new Lemon Law in Quebec. And with the time I see passing, I'm just going to go forward 2 slides. Yeah, perfect. This is what I'm referring to. So this is the new Lemon Law for seriously defective vehicles. So there's a creation of a scheme to cover seriously defective vehicles, which are said to be vehicles that have been subject of unsuccessful repair attempts, 3 times for the same defect, 12 times for unrelated defects, or when the repair remains unsuccessful after 30 days in the workshop. Or are unfit for normal use or substantially less useful as a result. And 3, the above occurs within 3 years or 60,000 kilometers of purchase. In that case, the Act provides for the ability of the government to declare a vehicle a lemon, essentially, or a seriously defective vehicle. Next slide, please. Thank you. The warranty of good working order. This is a big one, particularly for manufacturers and sellers of household appliances. It creates a new legal warranty. So Quebec already has implied warranties on defects. This is not that. This is another warranty that is added on top of that warranty, which provides that goods must be in good working order for a specific period of time. And I've listed the goods on that slide there that the legislature has already indicated in the Act. It allows them to add to this. Whether it will include small household appliances or not is the subject of debate currently. Those are the goods listed that will have this warranty of good working order. Now, for the duration, and I will note, and it's the same thing for the entire Act, the regulation which will govern the applicability of all of these provisions of Bill 29 has not been adopted as of yet. They're drafting it currently and in negotiations and discussions with various industry actors. at the moment to decide, but there will be a duration of the good working order for each of these goods. Whether that will be different for each good or the same for each good remains to be seen. So a lot about the application of the Act remains still to be determined, and you can be assured that there are lots of industry actors making their voices known on these issues. I'll just go quickly. This is the warranty of good working order, what it covers, parts and labor. And I'm just going to move on because we're running out of time. There's also, under Bill 29, guaranteed availability of spare parts and repair services. So while there already was this obligation to repair for a reasonable period of time, Bill 29 introduces much more specific and onerous provisions on the right to repair goods, when those repair parts must be provided, for how long. Again, all going to be the subject of a regulation which has not yet been adopted and is going to be going to clarify a lot of the new Act with respect to these issues. On the next slide, I've just indicated about the replacement parts have to be available for a reasonable period of time. Again, that duration will be determined by regulation at a reasonable price. Also have to be available in French, of course, in Quebec. That obligation, we know, always exists. And it's now been clarified further in Bill 29, specifically mentioned in the statute. Moving right along. I'm going to skip this slide, but obviously welcome any questions on it. It just provides some more detail about what property that manufacturers are going to be required to provide replacement parts on. It's property requiring maintenance work, and I provide some details on that. Lastly, administrative fines and penalties. I will just note here that while there are new and sort of increased administrative fines and penalties, the big one is on the next slide that I would just draw your attention to, which is, and you can see worldwide there, that always raises flags. So the Act increases fines for non-compliance to, and then we see the second one, $5,000 and the greater of $125,000 or 5% of worldwide sales. As one might imagine, 5% of worldwide sales for certain manufacturers would be a astronomical amount to pay as an administrative fine for a violation of the Quebec Consumer Protection Act. So this Act has teeth. It's got teeth, and we'll see how it will be applied. Next slide, please. Thank you. Just refer to this slide really quickly because not all of the provisions are in force yet. They sort of come into force over time. The Lemon Law I referred to before is already in force as of October 5th, 2023. April 5th, 2024, so that's just gone by. The right to inspection of a long-term contract of lease, those are now in force. And then coming into force later in 2025 and 2026, the power to impose those monetary penalties I was just describing, the availability of spare parts I was describing on October 5th, 2025. And then a year later, on October 5th, 2026, the warranty of good working order, which is obviously a big one, and that will be coming into force then. We're very hopeful that we'll have a regulation before then to understand how this is all going to be applied. But that is obviously a very important amendment to our Consumer Protection Act, and one which will certainly be the discussion, be the subject of lots of discussion and lots of claims, I assume, by plaintiffs' counsel. With that, I've probably gone over my time, and so I'll hand it back off to my colleague, Peter, who's going to talk a bit about some of the same things I've addressed, but from an Ontario perspective.
Thank you, Noah. And after having heard what Noah said, of course, that's why all of us in the rest of Canada commonly say Quebec is always different. Now, for me, for many of you in the audience may very well have heard me speaking in the past, because for the last couple of decades, from time to time, I've been speaking at conferences and webinars like this about product liability class actions. And for those of you who have heard me in the past, you may remember that often in the past, discussion from a defense perspective of product liability class action law in Canada has never been a very uplifting experience. You may recall hearing discussion about how low the threshold for certification of class actions in Canada has historically been, how some of the judges in Ontario for years had referred to product liability class actions as the quintessential class action because there's always going to be at least one common issue among all the class members. You may recall discussion about a wacky legal doctrine called waiver of tort that for a number of years until it was mercifully put to death by the Supreme Court a few years ago, plaintiff lawyers have been using to bootstrap their class actions. Well, I'm delighted to say that today is different. I'm going to break with tradition and tell you something good and deliver some good news from a defense perspective about product liability class actions. I'll be talking about something called no injury class actions, and I'm going to be speaking, I'll be discussing a handful of cases that demonstrate a very helpful evolution over the last 5 or 6 years in the common law provinces in this area of law, where we've seen courts all the way up to the Supreme Court of Canada happily putting logic above hysteria in the way they've been dealing this category of class action. And so briefly by way of overview, what you'll be hearing from me for my next 20 minutes as I walk through a handful of cases to demonstrate this development is we've seen from our courts a demonstration of a stiff upper lip that historically has been more associated with Canadian hockey players than Canadian judges. The developing jurisprudential message that our courts have been sending to the plaintiff's bar in these cases is the basic point that seems intuitively logical, that where there's no compensable harm, there is nothing to certify, so please don't waste our scarce judicial resources with meritless claims. The doctrinal rationale that our courts have really landed on for as the backbone for this message is the element of the certification test called preferable procedure, which typically comprises 3 objectives of class proceedings. And the courts have basically said that for no injury class actions, there is no justice to be accessed. Behavior modification of the defendant either in the facts has already been achieved through some other means, or it's unnecessary. And finally, that there's no judicial economy because proceeding with a class action would be a waste of judicial resources if no one has suffered any harm. So the first case that really started this ball rolling occurred about 5 or 6 years ago, the Richardson versus Samsung case. And often in these no injury class actions, a product recall is the start of the story. And that was the case here in Richardson and Samsung. This involved the Samsung Galaxy Note 7 cell phone. Many of you will probably recall it received a massive amount of media attention because it was found to be prone to overheating due to a defect in the lithium battery in the phone, and that created a risk of fire or explosion of cell phones that were being carried by people in their pockets or purses. Samsung immediately halted sales and initiated a recall of the product, and in conjunction with the recall, Samsung offered consumers a choice of a replacement of the phone or a full refund of the purchase price plus a modest gift certificate. Next slide, please. Despite that generous remedy that was offered in a very timely way by Samsung, the plaintiff lawyers jumped on the bandwagon and commenced a class action. They asserted that the compensation package that was provided by Samsung was inadequate, and they claimed it didn't properly reimburse the class members for all of the losses they may have suffered. The certification was denied by the court, and the court zeroed in primarily on, as I said, the preferable procedure element of the class action test. And the court found on the facts that the compensation program offered by Samsung was actually a preferable procedure to a class action for resolving any legitimate claims of the class members. And in that context, the court noted that the law does not demand perfect compensation. And if we can see the next slide, you'll see some very telling quotations from the court in that case. You'll see a couple of paragraphs. I'll just read the highlighted paragraph where the court made a comment that we rarely hear expressed about defendants by our courts. In my view, the defendant's prompt response in concert with Health Canada to safety issues, the recall, the termination of sales, and the compensation package demonstrates the response of a responsible corporate citizen. It is behavior that should be encouraged rather than discouraged. And this comment became a harbinger of what was to come in the subsequent cases. And if you can just go to the next slide, we'll see an additional comment by the court that is a very telling message that was sent out to the plaintiff's bar in this context of the complaint that the compensation package wasn't perfect. The court noted that as to the adequacy of the plan, it's quite possible that some people are out of pocket to some extent. It's also the case that some people sustained no loss at all, as the plaintiff's expert acknowledges. In any event, no recall program is likely to satisfy every purchaser. However, the law does not demand perfect compensation. Indeed, perfect compensation is unlikely, even if pursued by way of a class action. And that was a powerful message from the court that sent a signal to both defense and plaintiffs' bars that it really is possible for defendants and manufacturers of products that discover a defect in their product to avoid class actions if they can, in a bona fide way, develop appropriate corrective action that goes a long way to putting people whole. And if we can go to the next slide, please. The last comment from the court in Richardson that's worth noting is part of the claim of the plaintiff lawyers in this case was a claim for psychological upset along the lines of these downtrodden class members were really worried when they discovered that there was potentially a ticking time bomb in their phone, and gee, they're really upset. They should get something for that. And this is where we see that good old stiff upper lip coming through from the court, where the court made very short shrift of that argument, saying, furthermore, surely there is a certain amount of stress, upset, anxiety, inconvenience, and irritation associated with daily living. However, they must rise to a sufficient level beyond de minimis in order to attract compensation in excess of what was offered by the defendant. So that was put the end to the case against Samsung. The plaintiffs appealed it to the divisional court, and their appeal was dismissed. Now, if we can go to the next slide, please. I'm going to talk now about another case that I lived for about 5 or 6 years that started before COVID, went through the entire COVID period, and culminated in the post-pandemic period. This was McGuinness versus FCA Canada. And this was part of a band of litigation that the plaintiff lawyers sensationally described as Dieselgate. The claim against FCA followed on the heels of the claim that received a lot of media attention against Volkswagen. They involved something called alleged defeat devices, which related to the nitrogen oxide emissions from vehicles. And summarizing the story, 2 regulators in the United States, the Environmental Protection Agency and the California Air Resources Board, EPA and CARB, issued a notice of violation, which is an accusation against FCA, Fiat Chrysler Automobiles. The allegation from the regulators was that a few model years of two different models of vehicles contained what are these defeat devices, which basically is software that allegedly turns off the emission control system when a vehicle is in real life operation, but turns it on when the vehicle is being tested by the regulators to comply with emission standards. The plaintiff's theory is that the reason a manufacturer would install a defeat device of this type into a vehicle is that there's an inverse relationship, they say, between fuel economy and emission controls. And when the emission system is on, there's worse fuel economy. When the emission system is off, there's better fuel economy. So they were saying that the manufacturers of vehicles were doing this in order to provide better fuel economy after they had met the emission standards with the regulators. That was their theory. In any event, as time went on and the litigation ticked towards the certification motion, FCA resolved the claims that had been made by EPA and CARB and reached a resolution. In a nutshell, FCA implemented a software adjustment that satisfied the regulators that there wasn't a defeat device, and it was tested by the regulators, EPA and CARB, at their own testing facilities, and they determined that this approved emissions modification met the regulatory requirements for emissions of NOx without causing any adverse effect on fuel efficiency or vehicle performance. And if we can go to the next slide, please. Now, despite that, the plaintiffs forged ahead with their proposed class action, and they claimed two types of damages from FCA. They said that the vehicle owners had paid a premium price for what was characterized by the plaintiffs as clean diesel. And also they said that the approved emissions modification that FCA implemented in its arrangement with EPA and CARB actually did reduce fuel economy or result in adverse performance parameters. The judge, we argued that at the certification motion. Justice Bello Baba, may he rest in peace, was the certification judge. He assessed the evidence that was before the court and found with respect to premium price that the plaintiffs had not deduced any evidence at all that a premium price had been paid by any class member for a so-called clean diesel vehicle. And in any event, even if they had paid a premium price with the approved emissions modification, the class members got what they paid for because they had, with the AEM installed in their vehicles pursuant to the recall campaign by FCA, they had the vehicles that met any representations that had been made about clean diesel as well as fuel economy. On the second category, where they claimed that the AEM adversely affected fuel economy or vehicle performance, again, the judge found that the plaintiffs had failed to produce any evidence to support that bald allegation, and quite to the contrary, pointed to the evidence that we had put forward on behalf of FCA from EPA and CARB that demonstrated the testing by the regulators themselves had determined there was no adverse effect. Next slide, please. So at the certification motion, Justice Bello Baba started off with the point that and this rankled the plaintiff's lawyers because he starts off saying there's no dispute with the proposition that no action should be certified as a class proceeding without at least some evidence of compensable harm. Well, the plaintiffs actually disagreed with that. That is some evidence that at least one of the plaintiffs sustained an economic loss. And now if we can go to the next slide, please. After the opening comment, Justice Bello Baba then analyzed the evidence and zeroed in on the crux of his decision, where you see in paragraph 37, he first notes that where there's no evidence of compensable harm, a judge can dismiss a certification application in at least three ways. He can rely on 5.1b of the class definition, where there's no evidence of a class of two or more people who seek access to justice or can rely on 5.1e relating to the proposed plaintiffs are not suitable because they haven't suffered any loss and therefore don't have a cognizable claim at law. But ultimately, he then determined that the preferability under 5.1d, the preferable procedure, is the best and most appropriate element for dealing with these types of no injury, no property damage claims, because this cuts to the core of why we have class actions. And you see in paragraph 39, Justice Belobaba summed it up as absent compensable harm, there are no access to justice concerns, the defeat device has been or is being repaired, and thus behavior has been modified, and certifying this action would not advance any viable lawsuit and would only result in a waste of judicial resources. Next slide, please. And this paragraph is very important because of the second highlighted part, where Justice Belobaba said, it's not enough to point to an American consent decree, and that's the term for the settlement agreement with EPA and CARB, and the payments or other benefits that are being provided in the US, and expect without more that the same result should automatically follow in Canada. Those of us who represent defendants in product liability class actions have been encountering this irritating refrain from plaintiffs' counsel for decades. Whenever there's a product liability class action in Canada, always, without exception, there will have been a parallel litigation in the US. And whenever there's been a resolution of the US litigation, such as a settlement agreement reached by the defendant with the US plaintiffs, the Canadian plaintiff lawyers always trumpet that to our courts and would pronounce that Canadian consumers deserve the same treatment that was received in the US. For years, I and other defense counsel have been arguing in our courts that that is ridiculous, and it's completely irrelevant what a given defendant may do with a similar claim in another country, whether it's the US or a European country or an African country, etc., because the laws are different and the litigation universe is different, and particularly in the US, the universe of potential damages claims is entirely different from Canada. So we've often explained to the courts that there are a lot of good reasons why a defendant may reach a particular settlement in the US because of litigation risk exposure that simply does not translate to Canada. In any event, this is one of the very first times that a judge in Canada has explicitly addressed that and accepted overtly the point we've been making that whatever is happening in the US is not going to be relevant to Canadian litigation. Now, if we can, because I'm running out of time, I'm going to jump over a couple of cases and go to slide 46, please. This is the most recent case in this trend of cases. This is another case that I was involved in, acting for 4 of the 5 pharmaceutical company defendants. In this case, Palmer versus Teva. So I think, can we go back one slide? I think 45 is where it begins. So, and this is hot off the press. The Ontario Court of Appeal decision was just released 3 weeks ago on March 27th. But this was a pharmaceutical class action involving a well-known hypertension, high blood pressure drug called valsartan. It was discovered that some lots of valsartan were contaminated by a chemical called nitrosamines. The 2 types of nitrosamines have names that are about 25 letters long. Their abbreviations are NDMA and NDEA. They actually are naturally occurring chemicals that are omnipresent. There are nitrosamines in the air we breathe, the water we drink, a wide variety of foods that we consume, such as all kinds of smoked meats, beer, wine, cheese, etc. So we are exposed to nitrosamines through the course of our daily lives all the time. But nitrosamines were not supposed to be in valsartan. It was found in some samples of valsartan. So the 5 pharmaceutical companies conducted national recalls of some lots of production of valsartan. Sure enough, because it was a recall saying they were contaminated samples found, plaintiffs issued a class action on behalf of all people who had ingested valsartan. The plaintiff alleged that the NDMA and NDEA are carcinogenic in humans. The current state of science relevant to that allegation was actually very weak and questionable. It was based on animal studies, which for various good scientific reasons do not translate well to application to human beings. Partly because of that, and for another strategic reason I'll mention in a moment, the plaintiffs did not in this lawsuit claim that any member of the proposed class had actually developed cancer as a result of exposure to NDMA and NDEA in the valsartan. Next slide, please. Rather, what they pleaded was that they were seeking compensation for the exposure to an alleged increased risk of possibly developing cancer in the future. And the court accepted our arguments at certification. This was Justice Perel who heard this motion. That first of all, he accepted our submissions that the plaintiffs had failed to present evidence that established some basis in fact that nitrosamines can cause cancer in humans, and rather the scientific jury is still out on that. And then Justice Perel also agreed with our submission that the alleged increased risk of possibly developing cancer in the future is not legally compensable harm under the common law tort of negligence, and that the proposed class action was really for an apprehension of an abstraction, the fear of possibly having incurred an increased risk of developing cancer in the future. And the comments of Justice Perel in this context of explaining why this intangible possible increased risk is not compensable are helpful. If we can go to the next slide, please. You see, Justice Perel explained the baffling and fatal feature of the plaintiff's proposed class action is that unlike a product liability class action that's about compensation for concrete injuries caused by the defective product, the plaintiff's proposed class action is about compensation for an apprehension of an abstraction, increased risk of diagnosis of cancer, when the normative risk of a class member being diagnosed with cancer in his or her lifetime is 50-50, and that we had evidence about that in the course of a lifetime, the risk of any person developing cancer actually is 50-50, regardless of whether the class member ingested valsartan. The law provides remedies for concrete injuries, not abstract or speculative ones. And just pausing there, the strategic reason why the plaintiff counsel framed their claim this way, rather than seeking relief for people who develop cancer, is the process of determining whether any given person's cancer was caused by a given element, such as the nitrosamines, is inherently individualistic, and that militates against certification of a class action. So the plaintiff lawyers made a strategic decision to frame their case in the way they did, as talking about the increased risk, but of course it came back to bite them. And you see in the next paragraph on the next slide, Justice Perel elaborated on, again, the preferable procedure part of the test, where he said, if behavior management means using the litigation process to give a defendant and other defendants an education of their responsibilities and is something more or different than just punishment for bad behavior, the pharmaceutical companies are already heavily regulated and do not need an education about their legal responsibilities by a class action that will yield little to no compensation for the overwhelming majority of the class. And then about judicial economy, Justice Perel said, the proposed class action is a howitzer firing BBs and not mortar shots, which is an inefficiency metaphor for a class action with both inefficient overkill and inefficient underkill. Next slide, please. And as I mentioned, this case went to the Court of Appeal. We argued it in June of 2023. 3 weeks ago, on March 27th, the Ontario Court of Appeal issued its decision. They dismissed the plaintiff's appeal in its entirety and essentially reiterated the message from Justice Perel, where they quoted from a Supreme Court of Canada case, Babstock versus Atlantic Lottery, in paragraph 46, where they said, "There's no right to be free from the prospect of damage. There's only a right not to suffer damage that results from exposure to unreasonable risk. In other words, negligence in the air, the mere creation of risk, is not wrongful conduct." Next slide, please. And the last comment I'll note from the Court of Appeal was in relation to medical monitoring, where the plaintiffs were, part of the damages they were claiming was that because they'd been allegedly been exposed to this increased risk of possibly developing cancer in the future, every class member should be entitled to be reimbursed for the cost of cancer screening that they allegedly would require for the rest of their lives. And the Court of Appeal disagreed with that, saying, where there is no present injury, allowing damages for pure economic loss and the nature of medical monitoring and medical services costs is contrary to the principle that there is no liability for negligence in the air. And so finally, next slide, please. The bottom line message from this very helpful development in our courts in the common law provinces over the last 5 or 6 years is, where there is no harm, there's nothing to certify. And that is the end of my portion of the presentation. Now we'll move further to the west, and Michael Parrish in our Vancouver office will pick up from here.
Peter, thank you very much. Just for the audience, that is, you've seen the progression of hard work over 10 or 15 years by Peter and Noah and others to push the law in a particular direction. And it doesn't happen overnight, but it happens cumulatively over a series of cases. And I think you can see the good result that long and hard work can generate. Can go to the next slide, please. I'm going to talk about some different topics, not class actions, 2 British Columbia individual cases, and then 2 regulatory matters. And the reason I've picked 2 what I'll call individual action cases rather than class actions is that class actions are often more procedural than dealing with the merits at trial, because they very often don't go to trial. So the law is often pushed and addressed in more detail where you have trials and where the court is forced to essentially apply the law on a factual basis after trial. So I've picked 2 very interesting cases that address in great detail common legal issues that relate to products. So the first case is called Ding and Can-Am, and this involved the question of whether buses without seatbelts are unsafe and defective, and whether buses without seatbelts require bus companies or bus manufacturers to give passengers a warning that, 1, the bus has no seatbelt, and 2, that if you get on a bus without a seatbelt, that may pose a risk. It arose from a bus crash that was very bad. It turned on its side. Many passengers were injured. The glass shattered in a way that caused a lot of injuries, and it was quite a severe accident. Rather than bring a class action, this is a mass tort claim. So all of the passengers were hurt, sued the bus company, the bus manufacturer, and the bus operating companies. There were a number of them for negligence. The claims were negligent design for basically saying, look, bus company, and the bus company here was Prevost, which is a subsidiary of Volvo. saying the bus didn't have seatbelts and that made it defective. The glass that was used was tempered, not laminate, and the plaintiff said that was defective. Laminate would have been safer in this type of crash. And the bus company failed to warn passengers essentially that there are risks when the bus had no seatbelt. It proceeded to trial on what's called a representative action. So essentially, they selected one plaintiff. They tried the case of one plaintiff, and essentially the liability finding would then apply to all of the other plaintiffs. And I think there were 30 or 40 plaintiffs on the bus. And the bus was not a school bus. It was a highway coach bus. It was a long trial before Justice Myers, who was a very senior and experienced judge. I had the benefit of watching the trial. The trial occurred during COVID, so it was a hybrid trial. It happened in the courtroom, but it was broadcast on Zoom, and I was able to attend and watch on Zoom. So I was able to, at the corner of my desk, watch a 50-plus day trial. So it was very interesting. Next slide. At the trial, all of the liability claims were dismissed, and there was, and essentially the question of bus seatbelts in buses is kind of been wrestled with by manufacturers and regulators for like over 50 years. The prevailing theory up until very recently was that buses don't need seatbelts because they use a design element called compartmentalization. You probably remember being on a school bus when you're a child, and you're in kind of a big rubber box. You're in a padded seat. They're very high. You've got a padded seat in front of you. And the theory is essentially, if there's an accident, the passenger just kind of bounces around in his or her rubber box, and the injuries aren't that bad. And that generally is true. Buses are extremely safe. Bus accidents are extremely uncommon. The rate of injuries for bus passengers is extremely low. So by and large, this design theory has worked very well over a long period of time. The problem is when there is a rollover. When there is a rollover, compartmentalization works less or not at all, and because you basically fall out of your box and you get thrown around the bus and then you suffer injuries. The plaintiff's theory was essentially, look, this design theory of compartmentalization doesn't work always. Rollovers do occur, although they're very, very rare. This bus crash was a rollover, and in the circumstances, the bus ought to have had seatbelts. The particular bus was manufactured in, I think, 1998. At that time, no bus manufacturer in North America sold buses with seatbelts. Just simply, the industry didn't do it. It wasn't required by regulation, and the evidence at trial was it wasn't even technically feasible due to a bunch of engineering reasons. So at the time that Prevost sold this bus, it didn't contain seatbelts, wasn't required to have seatbelts, and no other manufacturer had seatbelts in North America. In the early 2000s, there were developments in technology, and Prevost and other bus companies started selling what are called retrofit kits. So they went out to the owners of buses and said, look, you have an old bus of ours, we have a seatbelt kit, you can actually install seatbelts now. It's going to cost $25,000 or $30,000 or $40,000, but if you want, we can sell you seatbelts, and there's a kit so you can install them retroactively. That retrofit kit was not, the uptake was very low, likely due to the cost, and the particular owners and operators of this bus declined to have the retrofit kit. Ultimately, Transport Canada just very recently in 2020 changed the regulations, which now require seatbelts to be on all new buses. So if a bus rolls off the line today, whether it's a school bus or a highway coach, it will have seatbelts. But there is still no requirement for older buses that are manufactured prior to the new regulation to have retrofits. So the question that was really the key question for the Court of Appeal is, well, is there a duty to warn on a bus company that even where the bus itself is not defectively designed at the time that it rolls off the line, where there is a subsequent advancement of the technology, does the bus company then need to go back to its to owners and say, hey, look, you should put a warning on the bus. You should tell passengers that there may be a risk that this bus doesn't have seatbelts and that if there's a rollover, they could become injured. That was the main question for the Court of Appeal. Next slide. The Court of Appeal, I talked at length, and if you read the case, it's a very interesting case, comes very close, I think, to suggesting or deciding that there may have been a duty to warn by both the bus manufacturer and the operators, but does not make that actual judgment. So there are some suggestions that the Court of Appeal is leaning to say, look, where you make a product and it's fine at the time you make it, but where you learn something later on, or there's a development in the technology, particularly where it relates to safety, in some circumstances, it may be necessary for the manufacturer to go back to the customers and say, look, something has changed. It's now safe. We now make a different or safer product. It may be necessary to warn customers or users of the product, but the BC Court of Appeal does not actually say that. They stop short. They say essentially that's a question for another day. And the reason they do that is because they agree with the trial judge that even if a warning had been given, it would not have made any difference, because the particular plaintiff essentially admitted that she knew the bus had no seatbelts. She understood generally what seatbelts do. She understood that if you don't have a seatbelt or wear a seatbelt, that you could be hurt in an accident. So what the Court of Appeal said is, look, there's no causation here, because even if if a warning had been required, it would not have made any difference for this plaintiff. So the Court of Appeal said, look, there's no evidence of causation. And as a result, it doesn't really require us to determine whether there was a duty to warn or a breach of the duty to warn, although they discuss it in 10 or 15 pages. So next slide. I think here are the key takeaways. For manufacturers, the duty to warn is ongoing. And even where there's no risk or no known risk when the product rolls off the line, if something occurs later on, either by knowledge of incidents or by developments in technology, a duty to warn may subsequently arise, which may require manufacturers to tell its customers in some way about the risk. The manufacturers, as the question is whether a manufacturer ought to know about a risk, a manufacturer is deemed to basically have the same level of knowledge as experts in the field. So if there are peer-reviewed scientific articles that identify a possible risk, even if the manufacturer doesn't actually know about those peer-reviewed articles because they don't have an engineer or scientist reading the journals on a daily basis, the fact that there is a reputable peer-reviewed article that comes to the conclusion that there is some type of risk, that knowledge may be imputed to the manufacturer. The fact that the likelihood of the danger or the risk of rising is remote, and here remember the risk of rollovers was very remote, doesn't mean a warning is not required. So the question of whether a warning is required is a multi-factor test that will consider many factors, but where there is a very low probability of the risk arising, but it is a very high consequence, like death or serious injuries, a warning may be required. Now, it's a more nuanced test than that, but that certainly is a component of it. Plaintiffs who wish to prove failure to warn must do two things. They must actually identify the warning. Like they must tell the court through it, and it's normally done through experts, this is what the warning should say. This is what the warning should have said. And here, there was no evidence as to what warning ought to have been put on the bus or where it ought to have been put on the bus. There was no expert evidence of that. And two, the individual plaintiff must then say, look, had I actually read that, I didn't know of this thing. Had I read that warning, I would have done something differently, and that would have avoided my injuries. So here, the plaintiff failed because there was no evidence of the specific warning that ought to have been given. And there was no evidence that the plaintiff would have modified their behavior had they been given such a warning. In fact, it was the opposite. The plaintiff said, yeah, I knew there was a risk without seatbelts, and yet she decided to get on the bus anyway. Next slide. This is a different case, Centurion and Source, and this just came down from our Court of Appeal a few weeks ago. This deals with a concept called pure economic loss. And Peter mentioned that you often see them in class actions. And essentially, as a general rule, claims in tort for pure economic loss are not allowed. You have to suffer property damage, or you have to suffer personal injury. Someone needs to be hurt, or someone's stuff needs to be damaged. The law allows certain exceptions to pure economic loss that are recognized by the Supreme Court of Canada. There's a very short list of them. And there are numerous cases where essentially plaintiffs are trying to wedge themselves into one of the categories of recognized categories of pure economic loss. One of the most common categories is called unsafe building, dangerous building defects. It comes from a case in the 1990s called Winnipeg Condo. A very heavily applied Supreme Court of Canada case. And what that case basically stands for is people who are involved in the manufacture of buildings, whether you're an engineer, whether you are a bricklayer, you owe all future owners and inhabitants of the building a duty and care in tort, where the work you perform on the building gives rise to a dangerous defect. Even where that dangerous defect is essentially latent and has not yet caused personal injury or property damage. So in Winnipeg Condo, the decks were essentially cracking and crumbling, and they were falling apart. No one had been hurt, and there had yet been no property damage, but there was an inherent defect, dangerous defect in the building. And what Supreme Court of Canada said is, look, we're going to make a special rule that where there is a dangerous defect in a building, even where no one's been hurt, and even where there's been no property damage, we are going to allow claims in pure economic loss to fix the building before someone does get hurt, because that makes a lot of sense for policy reasons. The Supreme Court of Canada says, look, it doesn't make sense for us to say, look, sorry, you have to wait till the defect is so bad until someone gets hurt. And then as soon as a balcony falls on someone's head and kills them, well, then you can bring a tort claim and then that will be fine. So the Supreme Court of Canada, from policy basis, says, look, for dangerous defects in buildings, and has been extended to products generally, where there is a dangerous defect in the product, that if it goes unabated and unremediated, there can be claims in pure economic loss which is limited to the cost of fixing them. This was one of those cases. So the plaintiffs, they were owners of a building. They weren't the developers. They bought it from the developers. Shortly after they purchased it, the building was condemned. Not just like the actual city pulled the occupancy permit. All of the occupants had to leave the building because it had inherent structural design defects, because the structural engineers were found to be unqualified to have designed the building. So the new owners sued various parties, including the structural engineers, for the cost of fixing the design defects, which were extensive. The engineers applied to strike the claim, saying, look, we had a bunch of contracts with the original developers, which limited our liability. Because of our contracts with the original developers, essentially we don't owe subsequent owners a duty of care and tort. And the engineers relied upon a more recent Supreme Court of Canada case called Maple Leaf Foods, where the Supreme Court of Canada said, look, in certain circumstances where there is a contractual relationship that governs the circumstances, the contractual relationship may essentially exclude the duty of care and tort. So in Maple Leaf Foods, it involved the sale of tainted meat. And in that case, Supreme Court of Canada said, look, there's no duty of care and tort because the supply chain contracts essentially covered the field for the risk of sharing between the supply chain parties. So we're not going to find a duty of care and tort relating to the sale of tainted meat for pure economic loss. So the engineers in this case were relying upon that theory to strike the owner's claim. The Chambers judge accepted that theory. I think certainly to my surprise and probably some others, said, you know what, actually that makes sense. I agree, I'm going to strike the claim. There were contracts between the professional engineers and the original developers, so the subsequent owners can't sue in tort. Next slide, please. Keep going. There we go. Right here. The Court of Appeal said, no. That is not what the Supreme Court of Canada meant in Maple Leaf Foods. The principles in Winnipeg Condo continue. They are not displaced by what the Supreme Court of Canada said in Maple Leaf Foods. There is a big difference between tainted meat, which causes commercial loss, not personal injury, and dangerous defects in Winnipeg Condo. So our Court of Appeal set aside the Chambers judge dismissal of the tort claim and said, look, Winnipeg Condo continues. There will almost always be a duty in tort owed by a building professional or a contractor to subsequent owners. And the fact that there are contracts at the time of construction won't displace a subsequent duty of tort to subsequent owners. Next slide. There is a very good, if you are interested in pure economic loss cases like Winnipeg Condo or Maple Leaf Foods, there is a very good discussion by the Court of Appeal as to what test is to be applied, how you apply it. Oftentimes when you see claims for pure economic loss, the first question is essentially, has another Canadian court recognized a claim like this previously? And which is called essentially has there been an analogous claim? Most times the plaintiff is always saying, yes, my claim is analogous to an existing claim, so recognize my claim as essentially being a recognized claim of pure economic loss. The defendant always says, no, this is not an analogous claim. This is a totally new claim. The plaintiff has to meet a different test, which is quite onerous, called the ANS test. So there's often this battle that goes on whether the claim is analogous or not. The British Columbia Court of Appeal, I think this is probably the best case in Canada for this point, sets out kind of a series of guidelines as to how to determine whether the claim is analogous or not. Next slide, please. An analogous in the mind of the British Columbia Court of Appeal means an analogous relationship in analogous circumstances. Kind of vague, but some guidance. Where the claim is not analogous to previous claims, as I said, the plaintiff has to satisfy a proximity test to essentially say, before you can have a claim of pure economic loss, the real question the court looks at is there a sufficient degree of proximity between the plaintiff and the defendant? And it's a complicated and nuanced test, but it's essentially, it has to be close enough to give rise to duty of care and tort. In Livent, the question was, did the auditors of Livent, remember it was a company that went bankrupt due to fraud, did the auditors owe a duty of care in tort to the shareholders who lost all their money when the company went bankrupt? And what was alleged is, look, auditors, you were negligent, you ought to have detected the fraud, and had you told the world and us shareholders, we would have, not invested or sold our shares, and we wouldn't have lost our money. In that case, Supreme Court of Canada said, no, that's simply, there's not enough of a relationship. There's not a close enough relationship. There's not enough proximity between the auditors of a company and the shareholder to give rise to a duty of care and tort. Next slide, please. So if you have a case of involving pure economic loss and you're dealing with those issues, the BC Court of Appeal case in Centurion is highly instructive, and whether it gets appealed to the Supreme Court of Canada, I think that's still in question. I have a few more minutes, and I'll go very quickly. I wanted to I have such a large group, just to remind manufacturers and sellers in Canada of their duties to report incidents under various statutes. Most products that are regulated in Canada, whether they're motor vehicles or consumer products or medical products or food, if there is a problem with the product that gives a reasonable likelihood that it could cause injury to a person, then there is normally a duty not only to tell consumers, but also to tell manufacturers or to tell the regulators. Next slide. I'll deal with two specifically. Consumer Product Safety Act, where there are incidents involving products which identify a risk or a problem in the product that could cause injury, even where the incident itself doesn't actually cause injury, you still have to report it to the Consumer Product Safety Directorate in writing within 10 days. And if you don't, there can be various penalties, including up to criminal prosecution. I would say that there is a significant amount of non-reporting in industry. Often sellers and manufacturers don't know about it, or they don't think the incident in question needs to be reported. My general advice is it's always better, when in doubt, report. And if you are unsure, it's possible to have no names conversations with the directorate and other regulators saying, look, this is the situation generally, should I report or not? And you'll often get a good direction from the regulator, which is, yes, please report. Next slide. For the Consumer Product Safety Directorate, there are some situations where there have been non-reporting and where fines have been levied. They haven't been significant. The fines have been $10,000 or $20,000 per infraction. As far as I can tell, the last fines were, I think, 2017 or 2018. Now, it may be that the website has not been updated, but the point being is that the Consumer Product Safety Directorate is not super aggressive with its monitoring of reporting, but there are fines. It has levied fines in what I'll call more extreme circumstances of non-reporting. But again, my general advice always is, understand your obligations, and when in doubt, either report or have a discussion with the directorate. A little different with Transport Canada. They are more aggressive with their reporting requirements. There is an amended regulation in 2019 which has very onerous reporting obligations to both to Transport Canada and to owners of vehicles where either there are safety defects, that is a defect that could hurt somebody, or where there is a non-compliance, which is essentially the vehicle doesn't meet the regulations for some reason, and it could be an extremely technical, a bolt is too short, or a bolt is not made out of the right metal. Even where it doesn't cause a safety risk, the non-compliance still needs to be reported immediately to Transport Canada, and for defects to owners within 60 days. Which, if you're trying to investigate a complicated failure mode where you're not really sure what is going on and it requires a lot of testing and you have to deal with suppliers and you're trying to kind of track down what is causing this problem and how many vehicles are affected and which supplier is involved, 60 days can go by very, very fast. And you often have to kind of give the information to Transport Canada as it comes in. And often you say, look, this is the problem we're investigating. We're not really sure of the root cause. We're not really sure how we're going to fix it, but we just wanted to tell you what's going on. And they're generally, they will accept that. In 2023, Transport Canada brought criminal charges against a manufacturer for failure to issue timely notice of defect. And they weren't sort of years off. They were, I think the earliest was 12 days late, and I think the longest was maybe like 42 days late. So we're not talking a huge amount of time. But they brought criminal charges, and ultimately the manufacturer pleaded guilty and had to pay a fine of $350,000 for not reporting defects and recalls of a fairly modest period of time after the deadline. So I think that there was a lot of background to that criminal proceeding, but it gives some indication as to how seriously Transport Canada takes the reporting requirements. We're almost done here. Next slide. The last thing I'll say is there is a new federal statute, Forced Labor and Child Labor in Supply Chains Act, an unwieldy name. It requires companies in Canada which meet certain financial thresholds and other thresholds to make an online report annually about essentially the company's efforts to ensure that there is no forced labor or child labor in their supply chain via an online questionnaire. The questionnaire has the first reporting is due May 31, 2024 this year. So if you are a large company or you act for a large company, next slide, you should figure out whether your company has a duty to report. And this essentially are the basic requirements. And if you do, an officer of the company has to essentially go and complete the online form. It's not that bad. It's not as bad as I thought it was going to be, but it will take some preparation. There are some very long, they require, I think, fairly extensive narrative answers about the company's efforts. So this is the first year. What the government does with these reports, whether they are audited, whether they are followed up on, whether anyone does anything, remains to be seen. But definitely the legal obligation exists. So if you think your company, if you manufacture or sell products in Canada and you fall within the reporting requirements, you must legally report by May 31 of this year. Those are all everything I have today, and hopefully we have a few minutes for questions. Thank you all.
Thank you, Michael. We do still have a couple minutes left for questions. So I've got one here that is in Noah's bailiwick. It relates to Quebec lemon law. Isn't the protection somewhat illusory if I need to go before a judge of the Court of Quebec or even the Superior Court absorbing legal fees and waiving the applicable delays in both of these courts? Noah?
It's a good question and a good point. Certainly going before the Superior Court, because that's what the scheme provides, right? That you can request a court to declare a vehicle being seriously defective if it meets one of those three criteria on the list. That said, I assume that in Quebec, like with other Consumer Protection Act obligations, that consumers will use this likely to threaten manufacturers that they will go to court if they think they have met one of those three criteria in the hopes of getting what they want. That said, I think the point is a good one. There will be delays in court, significant delays currently to get a declaration of a seriously defective vehicle. Now, a declaratory judgment like this might move faster than another case, but it might be somewhat illusory, as the question says.
Right. Thank you, Noah. And I guess just we'll do one question that's a little bit more common law related, although I think it would also apply to Quebec as well. But Mike, if you want to just comment briefly on this. We've talked a lot about manufacturers. Of course, another player in the supply chain are distributors and resellers. And so the question is, how responsible is a reseller of a manufacturer's products? Are there any things the reseller can do to mitigate the liability that it may face? I know that we could do an entire webinar on that, but do you have like a couple of points you would want to just provide in response to that one?
Yeah, and I think the standard of care on a distributor is circumstantial, and it depends on how much the distributor knows. If you are have a very close relationship with the manufacturer of the product, and like the recalls and the product bulletins come to you, the seller, then you have a duty to pass them on to the customer. If you have almost no relationship with the manufacturer and don't really do anything to understand or examine the product, and all you do is sell it, then you may have the duties on you may be less. My general, I think, advice to distributors to protect themselves is understand what you're selling, make reasonable due diligence to make sure what you're selling meets the applicable industry standards or the regulations, and to have a reasonably close relationship with the manufacturer. So if there are issues, then you know about them and you can pass them on to the customer.
Great, thanks. And the one thing I would add also is use your transaction paperwork with the manufacturer who's selling the products to you, the distributor, to your advantage. So now it's always going to depend on who's in the driver's seat in terms of the bargaining power. But if you try and include in your term sheet a defense and indemnification clause that would impose on the manufacturer the obligation to defend and indemnify the distributor from any claims that may be made against the distributor relating to a defect in the product, which is outside of the responsibility and control of the distributor, that will then help reduce or mitigate the potential risk down the road for the distributor. So I think we are now out of time. So I want to thank all of you very much for logging into this webinar. We hope that our comments have been helpful for you in grappling with these kinds of issues that may come up from time to time in the course of your own work. You'll see on the screen 2 QR codes. One is for our survey that we would ask you to take a few minutes to fill out if you don't mind, as we're always looking for feedback to help improve what we do. And the other QR code is for the Ontario and Quebec CPD, Continuing Professional Development Certificates, and links to both of those have been added to the chat as well. For our audience members that are from British Columbia, The Law Society of BC has been added to the chat as well, and you can get information for your continuing CPD credits there. And so on that note, on behalf of Michael, Noah, and myself, I thank you again for taking the time to be with us today. And if any of you have any questions regarding anything that we've discussed or anything else, certainly do not hesitate to contact us either by phone or email. You can find our contact information on the Fasken website for any one of us. So thank you very much and have a pleasant rest of your day.